medical list of accomplishments that he should be proud of. I'm sure that you are too. And thank you to your family, the public servants, serving in the military, serving in law enforcement, educating our children. You're a role model family. I do want to go back. This morning, I ended up turning to a channel that I never watch, just to see what was being said about the proceedings. I thought it was interesting that they were ridiculing some of my colleagues on this side of the aisle for bringing up the behavior of past Supreme Court hearings. This is really the appropriate venue to do it. I guess we could talk about it when we're reviewing intellectual property or something else, but contextually, this is the time to do that. And I think we all have to agree that the behavior in the Kavanaugh hearing was inappropriate. I hope we never get back to it. And I hope we can all agree that many of the behavior or the positions that some of my colleagues took on the other side of the aisle with Justice Barrett was abhorrent, and we should never do it again. That's why I'm so glad that for the most part, we behaved in an appropriate manner here. I'm going to get to some questions, if time allows, that relate to some other questions that my colleagues have asked. But Judge Barrett, did I understand correctly that at a young age you won a debate competition, or was it oratory competition?
I was in speech and debate. It was one team, and I did original oratory as my primary event.
And did you continue your debate competition? Did you continue to do that? First question. Did you continue to do debate competition?
Continue into
yeah, I mean, were you
college?
doing that in school and college?
I did not do it in college. No, I did it from middle school through high school, and stopped when I graduated high school.
I did too, and I recall with that we would get assigned a topic that wouldn't necessarily be one that we agreed with, but we had to argue it. Were you ever in a situation, or did you get to pick a topic and only argue the side that?
So I didn't do what it sounds like you're referencing is extemporaneous speaking.
Yeah.
I think I did that once in one competition. I did original oratory, which is where I wrote my own speech.
Okay. You've had an opportunity to debate a lot as a defense counsel, I would assume, in the court of law when you're debating a position. And the reason I ask that question is that yesterday when Senator Kennedy was asking you about the expanding the court, or what we call court packing, you said, I haven't really thought about it, but I hear the arguments on both sides. And I hear the argument on both sides. So could you briefly describe to me your perception of the arguments on both sides?
My understanding of the argument is about whether or not to expand the court beyond the 9 justices that are on the court right now, the 9 seats that are there. And
if you were to view, I mean, right now it's 9 is fine, 4 or more. I mean, that's really the 2 arguments. So do you understand, or have you heard any of the arguments for or against either side?
I'm not even sure about the 4. I've just heard people talking about putting more justices on the court, expressing concerns that the court has become politicized, that the court has become unbalanced in terms of what people perceive to be views of the majority of the justices. And so I've heard arguments about rebalancing the court on that side. And then there's the argument that many on the dais have stated about the inappropriateness of doing so, the concern that it might lead to some kind of a war of every time there's a new president adding justices to the court.
Actually, yesterday when Senator Whitehouse, I think it was Senator Booker, who observed Senator Whitehouse's presentation, made a comment about how Rhode Island, New Jersey being a bit bigger, would have a bigger graphic to display. I went back, I think that New Jersey is 6 times the size of Rhode Island. by square miles. North Carolina is 36 times the size of Rhode Island. And before my friends from Texas chime in, I would let them know that if Alaska were 2 states, they'd be the 3rd largest state. So I'm decided to use the White House format for dark money so that we have a balanced understanding of the fact that our proceedings here, the aspirations for the court, there is an ecosystem out there on both sides. As a matter of fact, we had a judicial nominee who actually participated in this ecosystem. I think you could reasonably assume if they participated in that ecosystem that they probably would have been an activist judge. The point that I make here is that we've seen this ecosystem mobilized to support you, and I think, Judge Jackson, you said you haven't had any encounter with Demand Justice. I don't know if you've had any encounter with some of these that are abbreviated, or I'm sorry, either acronyms or abbreviated, so I wouldn't expect you to. It would be interesting if we could, for the record, determine if you have had any interactions, but with respect—
I have not, Senator. I've never seen most of those.
That's good enough for me. I wouldn't expect you to be honest, sitting on the bench, but they are out there, and they have a specific plan. And their specific plan, as a matter of fact, I was inspired by Senator Whitehouse's seat, so I went out to Demand Justice. They have a specific plan. Step 1, 4 seats on the Supreme Court. We must add 4 seats on the Supreme Court to restore balance, which by their opinion is a majority with their view and their judicial philosophy. They're thrilled that President Biden has promised to appoint a commission. In fact, they're so thrilled that they want to make sure that they can influence the outside of the commission by endorsing their 4-seat strategy. They want to recruit 25,000 volunteers. This is on their website, their strategy, to influence the commission's recommendation. And then they want to nuke the filibuster. 51 votes to make a decision that could ultimately be to pack the courts. This is their stated goal. They're proud of it. Senator Whitehouse was talking about how the prior president was influenced by an organization. I would say that Senator Jackson and almost everybody that the president vetted before, Judge Jackson, are on this list. So I think it's intellectually dishonest to say that the administration, that my colleagues on the other side of the aisle, are not influenced by this organization. We've tracked some of the fundraising and support in re-elections. They're engaged, and they're influenced by it. But let me tell you what I'm really worried about with the court packing risk that we have today. We're talking about the ultimate destruction of 2 institutions. Back in January, Senator Schumer laid a vote down on the floor that ultimately would have reduced the majority of 60, the filibuster limit of 60, to 51. He was doing it as a way to pass a single bill, but we all know what happened when Senator Reid nuked the executive calendar for circuit court judges. It led to you only being subject to 51 votes to be confirmed. That nuked the executive calendar. In January, Senator Schumer was laying the groundwork for the same thing. Now, I worry that's the destruction of the Senate institution as far as I'm concerned. I think we have to be a consensus-based organization. We don't need to be a 100-member House of Representatives. And that vote happened. What disappointed me most about that vote is back when President Trump was calling on us and pressuring us to nuke the filibuster when we had control of Congress. I signed on to a letter with more than 60 members to say that I would never do that in the face of a Republican president whose policies I supported. I did that to send a very clear message. I respect this institution, and I respect the court, which almost certainly would have been, we would have had pressure from our side of the aisle to pack the court a little bit more. Now, every member who was here back when we signed that letter, who's on this committee, changed their position and voted to potentially nuke the filibuster just 2 months ago. So I hope you can understand my concern about the political winds and the potential damage that it could do to the Senate and do to the Supreme Court. I think it was Federalist Paper 78, where Hamilton talked about the vulnerability, or I think the feebleness. Now, he was arguing, I think, the case for lifetime appointments. But I do think that the Supreme Court is a fragile institution. And I do believe that if we think it's politicized now, think about how it would be if we destroy the institution of the Senate so that a strict party line, partisan vote, we expand the court. That's why court packing is important, and that's why we ask a question that I know you're not going to answer, but I know that Justice Breyer and Justice Ginsburg did. And if there's any Supreme Court justice listening right now, I wish that they would speak up, because I think your institution is in peril, and accelerating it to a truly political body is only one successful nuking of the filibuster vote away in the U.S. Senate. This is serious stuff. I was at Price Waterhouse. I was a partner at Price Waterhouse back during the Arthur Andersen Enron scandal. I saw about a 100-year-old top-tier Big Five consulting firm cease to exist because their reputation suffered. If we pack the court, the only thing that you all have, that the Supreme Court has, is its integrity and the esteem that the American people and the trust that they put into it. Packing the court could cause the Supreme Court to lose the trust of the American people. And I think if we want to expand the court, let's do it for the only valid reasons. Maybe the justices come to us and the Chief Justice come to us and say, the workload is too great. The times have changed. And then convince 60 members of this body to consider it. But when you've got a partisan organization here that's putting a pipeline of people in there that they think like them and have a judicial philosophy like them, how can any reasonable person think that this is just kind of fixing the mechanics? It's a partisan decision that even some of my colleagues on the other side of the aisle have taken the bait. So much so that they would reverse a commitment that they made with me when they signed that letter to say they would never nuke the filibuster and then nuke it. President Biden's on that list too. Back in 1983, he gave a rousing speech in a Judiciary Committee hearing saying, don't pack the court. He gave a rousing speech on the Senate floor saying, don't nuke the filibuster. But now we're in this posture to where we could destroy two institutions if we're not careful. So I actually hope that you can at some point study the issue thoroughly and understand the risk to this institution that you're likely to be confirmed to. It's serious. And you could end up being there. You'll have a lifetime appointment. You could actually be there and witness its demise real time if we allow it, the court to be packed. Now, I want to talk a little bit about I think you were a part of a case in Massachusetts that some people are casting as a pro-life versus pro-choice issue. Now, to be clear, I am Catholic and I am pro-life, and I'm proud to have signed and ratified pro-life bills in North Carolina when I was Speaker of the House that have withstood judicial scrutiny. But I don't really think that case was about pro-life. I think it was about free speech. So I want to ask you a few questions about it. And maybe you could describe it to me if your memory serves you. But it seems to me that the argument that you were a part of, I think that you joined with a couple of others, it seemed as if the argument was because the pro-life protesters were threatening and dangerous to women, attempting to enter the clinic. I'm not necessarily saying you put those words in the brief, but they were in there, and they were a hostile, noisy crowd in the face of protesters. Now, Am I correct that a part of the argument was because they were noisy, in-your-face protesters, they needed to be a little bit further away than people who were pro-choice advocates? Because as I understand it, I think the underlying law in Massachusetts was ultimately struck down unanimously by the Supreme Court. Is that correct?
Thank you, Senator. The brief that you...
Oh, by the way, I didn't expect you to respond to my riff on packing the court.
Yes.
Just to net it out, it's a bad idea. But back on this.
I understand. The brief that you are referencing was a brief that I worked on right after finishing my Supreme Court clerkship when I joined a big law firm in Massachusetts. This is maybe 2000 at the end of my clerkship. And it is a First Amendment free speech set of arguments that the lawyers at my firm, I was a part of a team representing clients who wanted to make an argument about buffer zones, which at that time had not yet been litigated all the way up to the Supreme Court.
Was it a buffer zone that put pro-life and pro-choice people in the same buffer, or one that argued that pro-life people were in your face and perhaps needed a bit bigger buffer than the pro-choice? I was just trying to understand the facts of the case.
I believe that it was viewpoint neutral, meaning it wasn't about what the people were saying. It was about clearing a path to allow people to enter the clinic. Mm-hmm. The laws at the time were about how far did people have to be kept back, whether they were pro-life or pro-choice, because if they were blocking the entrance.
Do you understand why the underlying law was ultimately deemed unconstitutional by the Supreme Court?
I didn't follow the jurisprudence. At that time, it had not been. And the First Circuit, this was a First Circuit brief. I don't remember what happened in the district court, but my clients wanted to argue in the First Circuit that the laws that allowed for the clearing of the path so that people could enter the clinic and have people stand back were constitutional and important, and the First Circuit agreed. I think ultimately, I don't know exactly, but I think ultimately, as you say, there was some litigation that went all the way to the Supreme Court, and the court had other jurisprudence about the extent to which buffer zones are constitutional.
Yeah, well, it looked at. I'm not an attorney. I watch Law and Order from time to time, and I'm not going to get into a debate, but on its face, it almost looked as if there was this notion that there was bad speech and good speech, that somehow, look, I'm somebody who's had protesters come to my house, get in my face, and be very nasty, 4 times by land and 2 times by sea. I live on a lake. Okay with them doing it as long as they stay off my lawn. In the last case, they didn't. But it almost felt like to me that those protesters who didn't like me needed to be a little bit further away than the protesters that maybe I would allow to be a little bit closer. It may not be right, but I'll make sure that I get my facts right before this afternoon in the second round. I want to go to sentencing. I'm not going to cover any of the ground that my colleagues have. I'm sympathetic to some of it, not necessarily all of it, because I think the details are something that we don't have possession of. I'm sure we're going to talk a little bit more about that. But I want to talk more about a pattern. I know, and I was really impacted by your description of family dinners and your uncles coming in uniforms and putting their guns up on the cupboard and having a sense of pride that you had family that served in law enforcement. There are a couple of cases. I'm very focused on law enforcement and backing the blue. I think that law enforcement, I talk with a lot of them, their morale is low. They feel like defund the police and some of these other efforts are already making a very difficult and dangerous job more difficult, more dangerous. there have been a few cases where you have recommended lower sentences that even, I think, the defense attorneys have. But I'm sure that if I were you and observing you yesterday, you would probably point to some mitigating circumstances or factors that are not necessarily available to the committee as a basis for doing that. I think in one case, the government recommended a 30-month sentence, and the defense recommended 21 months, and you gave them 18 months, and this was a third conviction for assaulting an officer. There was another one that was a lower sentence for, there were officer assaults, and it just seemed like it went lower. But I don't want to get into those because you may have factors that that you would point to that would justify the decision. I've got a question about, now, see, that's at an atomic level. I mean, you're looking at the facts of the case, you're looking at the defendant, and as you've described in some of the other cases here, you made a judgment that you thought was fair and that was in bounds with your peer group. But back at the beginning of the COVID pandemic, I believe you made this statement, and I'll give you time to provide context if it's out of context, but in the interest of time, I'm only going to read the most striking. You said the obvious increased risk of harm that the COVID-19 pandemic poses to individuals who have been detained in the districts, that's the District of Columbia's correctional facilities, reasonably suggests that each and every, and I think that means everyone, every defendant who is currently in the D.C. Department of Corrections custody and who thus cannot take independent measures to control their own hygiene and distance themselves from others should be released. I checked in April of 2020, I think that's when you made the statement, that there were 12 or 1,600, let's call it 1,200, I'll be conservative, people in the Department of Corrections. Do I read that statement to say that you felt, given the circumstances of the time, they should all be released? Because that's broad. That's not looking at their individual cases.
No, Senator, you don't read it correctly.
Okay.
It was not a statement. It was a line in an opinion. And the beginning of the COVID-19 pandemic was a really, obviously, horrible and difficult time for all of us. Yep. And what was happening at the beginning in the prisons, which was part of the criminal justice system that as judges we were involved in.
I tracked it quick. Because I do not want to go over. I don't go over. But let me just give you a little bit more context. I've actually written letters to the Department of Justice encouraging the release of nonviolent offenders in North Carolina at a federal correctional facility. I've also supported early release programs. I voted and supported the First Step Act. I, as Speaker of the House, was the first speaker in probably 2 decades that actually did the Justice Reinvestment Act early release of nonviolent prisoners. But how can I not read this to say that perhaps they should be released irrespective of the crime for which they've been charged?
Senator, if you read 2 more sentences down, that is precisely what I focus on. This is a case, United States versus Wiggins, where I was setting up my analysis as to why I would not be releasing Mr. Wiggins in this case. He was arguing essentially what I said in that statement. He was arguing that the circumstances of COVID-19, which at that point was rampant in the prisons, we had not had a vaccine, there were very difficult circumstances for prisoners who could not be separated from each other in the context of our jails. And as I say at the beginning of that opinion, at that point, COVID was ravaging the jail. And the question for courts under the statute that Congress has enacted for compassionate release was whether COVID-19, a pandemic in the jail, was an extraordinary and exceptional circumstance or extraordinary and compelling circumstance that should warrant release. What I said in that statement that you read was it would seem as though something like a deadly pandemic rampant in the jails would justify releasing everyone. But I go on to say, in that very opinion, Congress has indicated that we have to take each case individually. We have to look at the harm to the community that might be caused by the release of individual people. We can't just release everybody, I said in that opinion. And so
I wanted to give you, I'm sorry to interrupt you, but I'm on,
that's all right.
on 4 minutes. But I feel like I also had my staff provided me this morning in very, very small type, recidivism and federal sentencing outcomes. You know, I've said, I'm on record as saying that I want people out. I want them to have them an opportunity to reenter society, become productive members, and I've got a track record for ratifying bills to that effect and supporting similar measures since I've been here in the Senate. I'm going to continue to work on it. But tell me why the numbers that I'm looking here, we have recidivism rate, the most recent one that I have before me, and I'd be happy to share it. I'll ask with to have this submitted to the record. But I think an 8-year look back says that 49% of the people incarcerated are rearrested within 8 years. If you take a look at the types that are most likely to be reoffending, it's firearms offenders, robbery offenders, violent offenders reoffended at a higher rate than nonviolent offenders. And so if I look at this and I look at your philosophy with respect, and it's admirable. I said that the content of your character would be demonstrated this week in my opening statement, and it has been. And one of the things that are first among them are your compassion and your belief that people can redeem themselves. But if you look at some of the cases that my colleagues have brought up, and if you look at even with the context that you provided on the last statement about the Department of Corrections statement in Wiggins, can you understand how some of us may think that your compassion could lead to bad results based on the numbers that we have here with recidivism, that Congress may need to work more on that to make sure that we get it right? Can you understand how somebody who, from our side of the aisle, could see that maybe there is some pattern to give the benefit of the doubt to someone who has been incarcerated, in some cases with very serious crimes?
Thank you, Senator. I don't recall saying anything about compassion in the way that you're describing it.
No. I'm just saying that if I take a look at your responses to some of my colleagues' questions and your statements to some of the defendants, it seems as though you're a very kind person and that there's at least a level of empathy that enters into your treatment of a defendant that some could view as maybe beyond what some of us would be comfortable with respect to administering justice.
Thank you for letting me clarify. The statements that I made about my practices as a trial judge, which I'm no longer a trial judge, but were intended to explain how trial judges operate and how they impose sentences within the framework that Congress has provided. The statute that applies to us tells us to look at all of the various factors that Congress has set forward, including the nature and circumstances of the offense, the history of the and characteristics of the defendant, and it tells us that we should be imposing a sentence sufficient but not greater than necessary to promote the purposes of punishment. Congress also tells us that one of the purposes of punishment is rehabilitation. My attempts to communicate directly with defendants is about public safety, because most of the people who are incarcerated via the federal system and even via the state system will come out, will be a part of our communities again. And so it is to our entire benefit, as Congress has recognized, to ensure that people who come out stop committing crimes. And so what I convey, or did when I was a trial judge, as I sentenced people to very lengthy periods of incarceration, was you are getting your day in court. You are able to say what you want to say, but you have to sit here and listen to my reading into the record the victim statements in this case. You have to go away understanding that I am imposing consequences for your decision to engage in criminal behavior. And the reason why I did that, I've said, is because I recognized as a defender that there were lots of people in our system who, instead of taking responsibility for what they had done and then ultimately understanding the harm and potentially not doing it again, instead of that, those people were bitter, they were angry, they were feeling victimized because they didn't get a chance to say what they wanted to say, because nobody explained to them that drug crimes are really serious crimes. Nobody said to them, do you understand that there are children who will never have normal lives because you sold crack to their parents and now they're in a vortex of addiction? Do you understand that, Mr. Defendant? I was the one in my sentencing practices who explained those things in an interest of furthering Congress's direction that we're supposed to be sentencing people so that they can ultimately be rehabilitated to the benefit of society as a whole.
I appreciate that, Judge Sachs. I just still note that virtually half of those people, statistically speaking, that you gave that speech to within 8 years were back in prison, and in some cases for more serious offenses than the first incarceration. Thank you, Mr. Chair.
Thanks, Senator, for that line of questioning. And I've noted that you joined a letter with Senator Grassley and myself in March of 2020 at the earliest stages of this, talking about release under these similar circumstances. And of course, we all said at the same time, low risk inmates would be considered, but
only low risk inmates.
yes.
Yep.
And I wanted to make that note for the record. We're going to start the second round of questions, 20 minutes each, and I'll kick it off. This is an unusual document, this Constitution of ours, which has taken up so much time in the hearing, the conversation about it. And it is really at the core of public service. I don't know that there's a place that you can take a job at the federal level in any branch of government without taking an oath to defend this document. I don't know about other countries and the oaths that might be required, but we even within the Constitution spell out the oath to be taken by the President of the United States, and it's to uphold and defend this document. And there's great debate about just what this document means in today's context. We understand the wisdom, the inherent wisdom of the document, and the fact that we're still here some 230 years later with the design of a government that has endured longer than virtually any other democracy, which of course speaks to the wisdom of the founding fathers and their plan for this nation. But we also understand, taking an honest look at it, that you barely get into this document, Article 1, Section 2, then you run into a problem. Because in Article 1, Section 2, the article that relates to Congress, they talk about who will be counted for apportionment among the states, and there is that awful reference to 3/5 of all other persons, which, though the document never mentions the word slavery or slaves, what was being spelled out here by the founding fathers was, how are we going to count these slaves? And for apportionment purposes, they were to be counted as 3/5 of a person, which is a horrible notion by any standard, but the wise founding fathers included it. trying to deal with the reality of their day. I hear debates back and forth of originalists, textualists, and others, and you've been asked as often as any nominee what your thought is. You've talked about stay in your own lane judiciary and methodology and like. But I'd like to explore for just a moment, without asking you to get in any particular fact pattern, the reality of a couple things. First, when the Bill of Rights was written, the First Amendment to it made certain to guarantee freedom of press. Freedom of the press in 1790 was, of course, referring to a piece of paper, a newspaper, and saying that there would be freedom to engage in that process in this democracy of America. Now that freedom of press